on this morning's docket. Case number 106406, State of Kansas v. Dern.
May it please the Court, I'm Heather Sussman with the Appellate Defender Office here on behalf of the defendant, Mr. Dern, and I would like to request 4 minutes for rebuttal, please.
4 minutes is granted.
Thank you. I was going to start off this morning talking about our sufficiency issue on the corpus delicti argument. I think that we're definitely troubled by the Court of Appeals' reliance on what amounts to very little evidence to support the idea that there was a conviction or that there was an actual crime committed against CD in this case. The evidence that the Court of Appeals relied on to support the corpus delicti beyond Mr. Dern's confession in and of itself was almost entirely based on the fact that he had repeatedly made those statements to several different witnesses, and then also CD's statement to her mother that what she had seen had made her sad and that she didn't want to see it again. And that was referring to FD's statements. And I think it's important to note that FD's statements were entirely limited to actions that occurred allegedly occurred between my client and FD. She didn't make any statements that CD had participated in that information. And so our argument is essentially that the repeated statements, even though they were made to a variety of different people, that the idea of corpus delicti is to prevent the conviction based on a confession, and so, or solely based on a confession. And so our allegation is to the Court of Appeals relying on the fact that he had made that statement multiple times. I think that's erroneous to say that that supports the corpus delicti in this case, because frankly, his allegation was that that was a lie that he had told and that he had falsely confessed, and that a false confession, regardless of how many times you repeat it, is false. It's false the first time, it's false the second time, it's false the third time. And the fact that it might have been repeated multiple times does not in any way lend trustworthiness to the idea that he's actually telling the truth somehow as the repeated things go on. And then all you're left with is CD's statement, which was pretty vague. And so our concern here is that by relying on FD's statement specifically, that there was a crime that had occurred between my client and FD, to support the idea that that somehow corroborates his confession as to the crimes involving CD, that I think there's a disconnect there fundamentally between what would be therefore substantial independent evidence that there actually had been a crime that had occurred between my client and CD, both on the aggravated criminal sodomy and the aggravated indecent liberties.
Let me ask you on that one. The 609 letters made reference to a Court of Appeals decision, State versus McGill, which is presently up on petition for review. Mm-hmm. That opinion divided by each member of the panel with a different view. One of the views that was put out by now Justice Stiegel, and this is what I want you to reference, is that a review of Kansas law would show a strain of, this is the way I interpret it, would show a strain of cases that recognize the corpus delicti rule specifically with just the trustworthiness element without the evidence of body of the crime, if you will. Mm-hmm. Why is that wrong?
Well, and
I assume you believe it is. So,
I do with respect to Justice Stiegel. I think the response to that is that I think that the language that is being cited to from the Supreme Court opinions on that, we need to be careful, essentially, when we look at those Supreme Court opinions. I mean, I think what they're saying there is that you can use evidence that may not be sufficient in and of itself to support a conviction to corroborate the defendant's confession in order to support the corpus delicti. And our allegation is that trustworthiness, I don't know if that's really a weighing or how you want to consider that. But that trustworthiness idea there still requires that there's some independent evidence that the crime occurred outside of the confession, and that the just the trustworthiness. I mean, that basically what the evidence that needs to be corroborated there has to be something beyond the statements made by the defendant. And so the trustworthiness is wholly dependent on there being something substantially related to the actual crime. So for instance, I think like in his dissent, Judge Ashton used several examples, but the idea that you can't take a statement by the defendant, the confession by the defendant, and take extrinsic sort of sideline information, confirm that, and then call that trustworthiness. And to the extent that the past cases have allowed such things in order to uphold convictions because of desire to avoid reversing on those convictions, that would be erroneous application of that law.
One other question in this regard. The corpus delicti rule that you're advocating for, some might say the current law, but at least the one you're advocating for, does do a disservice in terms of prosecution for some really, for a class of victims that are very difficult to protect, the developmentally disabled, the very small children. It becomes very difficult to prosecute crimes against them based on the current rule. What you're saying is the current rule. Wouldn't you agree with that?
I would. And I think that that's part of the reason why in the past we've tried to muddy those lines inappropriately, is because it does make that kind of prosecution more difficult. It certainly does not make it impossible by any means, and I think this court and other courts have repeatedly said that the independent, and I guess that's maybe what I want to specifically focus on, is that what I'm really concerned with here is this independent evidence to support the crime. That independent evidence doesn't have to be a lot necessarily to cooperate. I mean, for instance, if you're talking about a child who might be too young to testify to some kind of a sexual molestation, and it's not the kind of crime that would, for instance, necessarily render obvious physical harm to the child, there could be other things that could support the idea that a crime had been committed. I've seen other cases where there's been testimony from experts that indicate that because the child had repeated and unusual amounts of urinary tract infections, that could be a sign of molestation. I mean, if you have, there's the possibility of having other evidence and other experts that could come in to support that. The real problem that we have here in this case, and the reason why we're specifically concerned with that independent idea, is that the evidence that the state's relying on here is primarily FD's statements about her participation in acts with my client to support this idea that then CD's statement that, oh, that made me sad, meant that there was a crime that actually occurred. And our allegation is that you can't, that's just not enough to support that there was even a crime that actually occurred against CD in this case. So, and obviously it's a difficult thing to review when you're talking about allegations like this against young children. But I think that the court has long held, and this is such an extensive body of law that has repeatedly upheld over and over again, that this idea of corpus delicti is so important to us because the idea of false confessions has permeated our history for so long, and that they've been so significant, and that even though there are other ways in order to get out confessions like voluntariness, that there's a lot of times when a voluntary statement that's not otherwise allowed to be excluded from evidence could still be false. And that's the problem here, is that you don't want a conviction for something that wasn't actually a crime or didn't actually occur.
So the common law rule that we have,
I think it needs to be.
Our choices are protections against false confessions versus very vulnerable victims and the difficulty of being able to prosecute crimes against them, given this rule.
And I
Is there
would,
anything else on either side of the balancing?
well, I think that's sort of setting it up as it has to be either or, and I don't know that that's necessarily true. Like I said, I think the problem here is that you can potentially support it with relatively little corroborating evidence. It's just that I think in this case that just wasn't available.
What prevents a defendant from arguing the trustworthiness of statements that your client made? What prevents him from making the very argument you just made, that it's not trustworthy because there's no corroborating evidence, there's not this, there's not that? Why do we need the additional protection of the corpus delicti rule?
I think because there are a variety of crimes out there that can be committed without necessarily leaving, a body, as it were, which is what the original idea here was, that there had to be a body to prove that there was murder. And because there are so many crimes that don't necessarily have that obvious proof, that we have to err on the side of having something else to support it beyond just the defendant's own confession, especially in a case like this where it's then recanted. And so I think that's why this particular protection, it doesn't come up all that often, but I think that when it does, it's in situations that are particularly important.
But why, it may be an extension of what Justice Rosen was asking, why can't a jury look at a defendant and really assess the credibility of whether the statement's been recanted or not, and look at the entire circumstances of those first statements to see if there were coercive or reasons he might have caved in, and really just make a credibility determination?
Well, and I guess essentially that's what happened in this case, was they obviously made a credibility determination and decided it against my client because he ended up convicted of those crimes. The idea of the sufficiency of the evidence, and the reason why it's raised as a sufficiency problem, is because legally, I think, regardless of the believability of the defendant's statements or the believability of his recantation, that's why we require a separate showing of just the most basic idea that there's actually been a crime committed here before we're going to allow a credibility determination to result in the guilt. And that's sort of the distinction that we're trying to make here, is that the jury's determination of whether or not the client's confession may or may not be credible, or whether his recantation is credible, is going to determine on a lot of factors. But those factors don't necessarily prove whether or not there was actually a crime committed in this specific case. And so that's why we require that basic amount of evidence in order to get over that hurdle. And that ends up being a legal issue as opposed to a credibility determination under the sufficiency. I see my time has run out. If the court has no other specific questions, I can, if the court has other specific questions, I can dip into my rebuttal time if I need to, if the court wants to talk about any of the other issues, but otherwise I'll submit the rest of those on the brief.
Any more questions?
I do want to touch on the invited error ruling from the Court of Appeals, because that's kind of another important point with this. And my understanding is the defendant did not object when the instruction, which was ended up being alternative means, was proposed. And the Court of Appeals in this case and in several others has labeled this to be an invited error.
Right.
What's your argument about that?
Well, our argument is that because the alternative means issue is at its heart a sufficiency issue, that because it's a sufficiency issue, the invited error shouldn't apply. Although I will say that in preparing for argument this morning, I actually have a fundamental disagreement, I think, with the idea that this might even be invited error to begin with. The Court of Appeals and I think even us as parties really were relying on the idea that the PIC instruction was requested by defense counsel. But just to be clear, in the actual requested instructions that were submitted before the jury trial, defense counsel requested the aggravated sodomy PIC instruction, but that only says sodomy. It doesn't, and she did not actually include the specific language from the sodomy statute that defines it, that we're
And the
that were
definition's what throws
And the
the alternative means question into play.
right. And so I don't believe that this actually rises to the invited error level, even if the court decides that invited error is an appropriate consideration here. But our first argument is that because it's a sufficiency problem, that it shouldn't be subject to invited error, because you can't invite the state to perform sufficient evidence. I mean, at the end of the day, they're the ones who are putting on the case. It's their burden to prove the case. And at the end of the day, if they want to submit a jury instruction and agree to a jury instruction that includes a definition with all these alternative means, then it's up to them to submit sufficient evidence of each of those alternative means.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, Sherry Shook, Pottawatomie County Attorney for the state of Kansas and the appellee here. I guess I'll just start with the issues that the appellant was able to cover with the court. The sufficiency of the evidence issue regarding CD. I'm not familiar completely with the McGill case, but I do believe that confession should be looked at on a trustworthiness and whether the confession should be enough. In this case,
Counselor, excuse
yes.
me, the principle is corpus delicti, which
Yes.
we've all been told means the body of the crime. So how do we get a requirement that you prove the body of the crime means you just prove the defendant's believable?
well, I don't think I'm not saying that, but I don't believe that there can be that this is the amount of evidence necessary to say the corpus delicti has been obtained. And in this case, they want to say, well, there just wasn't sufficient evidence to say this. How much evidence is sufficient evidence? Well, I believe that a jury can determine whether there is a sufficiency of that evidence. In regards to CD, when the statement was first made, when FD first disclosed to her mother, CD was standing right there. It wasn't just, I don't ever want to, Daddy made me sad. She said, I don't ever want to see that again. That denotes something, not just I'm sad because I'm sad. It denotes something. During the trial, all of the testimony from the witnesses, to include the defendant, the mother, the pastor, everything that they discussed involving these children, even prior to the actual confession, involved both the children and something happening to both of the girls, not just FD, but CD. It was taken as a whole that these events occurred to both of them.
At the same time.
At the same time. And that's what was presented to the jury. Is it overwhelming circumstantial evidence? No. But I don't believe that it has to be. And when you look at it in conjunction with that confession, it does make that confession trustworthy. One of the reasons that the defendant posited for saying, I'm confessing only because of these reasons, one of them he indicated was, well, I just said, I regurgitated what my wife had told me the girls had said. That this is what happened. That's how my confession came about. But that's not actually true. The confession was a progression of how the abuse occurred and actually started with CD. That was the defendant's confession. That it actually began with her, not FD, who is the one that made the very detailed disclosure to the mother with the CD there all at the same time. The progression of the abuse really involved CD initially almost exclusively with FD being on the peripheral. Both girls always there, but on the peripheral. And then culminating in the event or the incident in which we charged with, where they were both involved, both of them there actively participating.
To make sure my recollection is good at this point, there's nothing that FD said that implicated a crime against CD. Is that right?
Did she say, Daddy made me and CD do this? No, she did not.
Or I saw Daddy do something to CD. So we don't have, I'm trying to get at your notion of the crime occurred to both girls at the same time, and I know that's what he said. I'm trying to get to whether we have anything that links that statement to any other evidence besides outside the confessions.
Well, and again, I believe that CD's statement, completely on the heels of FD's disclosure, very graphic disclosure of what occurred with Daddy and how he touched her, that type of thing, because she was visibly showing how that occurred. CD became withdrawn. She said, Daddy made me sad, and I don't ever want to see that again. That it's more than just a descriptive, I'm just sad and I don't want to see Daddy again. It's, I don't want to see that again. I don't want to see what happened again. I don't want to be there again. And I think that was the argument that the state used. It is the argument, and I believe that's how the jury took it as well.
All of which could be that she didn't want to see what her daddy was doing to her sister.
It certainly could be, yes. But again, it does come down to how much evidence becomes sufficient. It indicates that the corroboration of the evidence should fortify the truth of the confession without independent establishment of the crime. Well, I think that occurred in this case. It fortified the truth of the confession that he would eventually give. So the state's position would be that there was sufficient evidence and that the jury was correct in finding that there was sufficient evidence, and the Court of Appeals was correct in finding that there was sufficient evidence as to CD. Most of the other issues, I believe, are actually controlled by current case law. Whether our 6455 motion, I think now is obviously, Prime makes it pretty specific that KSA 6455D is its own exception. When I was the trial attorney, when I filed my 6455 motion, I did do it under D, but I did it also in conjunction with looking at it to whether it fell within exceptions that applied to B as well. I used the Hart case. The court did find it was relevant, did a probative, prejudicial and probative balancing, and did admit it under Hart, which I don't believe has been overturned. It isn't bad case law, but Prime makes it pretty specific that that in and of itself is the exception under these type of cases. And although I think the Court of Appeals found that the trial court and allowed it for the wrong reason, but it should still have been allowed. So
Our case law also is pretty clear that criminal sodomy is an alternative means crime. So what do we do with that?
Your Honor, the reality is it was a mistake by the state not to make sure that those were set out specifically. And in this case, I would have to say that Schreiner does save me. It does save this in this case because it does exist. Schreiner is out there. And there was no objection to the jury instruction as it was set out. In this case, also, I do have to say that there's only one possible way that this could have happened. There's only one alternative means that it could have happened here. There are, I think, 4 different alternative means. There was no evidence presented that could possibly confuse a jury that it could have been this one or it could have been that one. It could only be.
Did you argue, that's a harmless error
Yes.
argument. Did you argue that in your briefs or anywhere in this?
I know I did harmless error in many of the issues, Your Honor, and I don't know if I did it in that one or not. I can look and see real quick.
My note is to myself in looking at this is that you didn't. That's why I want to.
I'm sorry, sir?
My note to myself when not that that's accurate, but was that you didn't. So I just want to.
And that
Get that
could
from
be,
You haven't.
no, Judge, I am looking at my brief right here, and I did argue Schreiner.
So let's talk about invited error on that one. I think your opposing counsel is right that on the sodomy charge, the proposed instruction didn't include the definition of sodomy, which is where the alternative means mischief occurs. So I'm not sure that part of your argument holds up under the facts, but there was no objection. Now, our case law has been that when you don't make an objection to a jury instruction, your penalty for that is clear error to go forward. And So I'm trying to wrestle with, shouldn't we have something else in order to get to an invited error determination? I mean, a lot of our case law on invited error, at least at this court's level, has been counsel saying, no, I want this instruction, judge. I want you to give it exactly this way, and I don't want those lesser included offenses. And we've said there, okay, if you're going to be aggressive about it, then we'll tag you with invited error. But we don't have any case at this court that says just the failure to object is invited error. And we have several Court of Appeals decisions, I know that. But I'm trying to get at really what should be the rule. Is it really fair to tag them twice to say there's clear error and then also invited error? That doesn't make sense to me.
I don't know how to answer the court's question in regards to that. I do believe you have an affirmative requirement that if you disagree with a jury instruction, if you think it is erroneous, if you think that there is an alternative to that, that you have a duty to advise the court of that. You have a duty to advise counsel of that. Otherwise, you have to presume that what you're presenting is accurate, that it is something that is jointly agreed upon and going to a jury without much more. Sometimes there are bar sides, sometimes there are informal objections to jury instructions or how it might go out, but there is an objection. There is something that voices that. So yes, I believe that even a defendant has an affirmative duty to say, if this isn't the way I want it, then I have to have it done. I continue to have defense counsels that say, I object to the verdict form. I wanted to have not guilty first and guilty first. That's been settled. I've never had a judge reverse those. They'll tell them that, but it is brought up at every trial that I ever do. So I think that it isn't. There shouldn't be more. If you don't object, then that's the standard. The standard that we use currently should be the standard the court uses.
Why do we have the statute that seems to suggest if you don't object, then you have a higher burden on appeal, i.e. clearly erroneous? If invited error takes care of everything, why do we have that provision in the statute?
I don't know if I can answer that clearly, Your Honor. The question was whether I think we should have more than that, or should that stand as invited error, and that would be my position that it does. Obviously there is a statute and that says that if you don't object, you have to have more to it.
I think the legal contention that is underneath the question is your invited error rule as proposed would make the statute unnecessary. And we don't usually do that.
That may be, yes, that could be.
Any further presentation?
Your Honor, I would just say that essentially for this court to overturn the defendant's convictions, essentially, you would have to overrule Prine, Brown, Wagoner, Schreiner. I mean, there are a lot of cases out there that would have to be overruled in order for these convictions to be overturned, because distinguishing them isn't really going to do anything, since the majority of these cases are, as far as the underlying facts relate to the respective issues, are not distinguishable. So you would have to overrule them. We would ask that the court affirm the Court of Appeals, which affirmed the trial or the jury conviction.
Any more questions? Thank you, counsel.
May it please the court, just to try to answer maybe a little bit more completely your question, Chief Justice Ness. I think when it comes to the concept of invited error in this context, I mean, typically we've said invited error has to require some kind of affirmative requesting or insistence that your instruction is going to have something erroneous in it, and then you can't later complain about that. Now, we've said separately that there is this different standard for just failing to object to a jury instruction versus actually objecting to a jury instruction, and that leads to a slightly different standard when we're reviewing those. The convoluting factor here is that when you're talking about alternative means, the state has the ability to go forward on whatever theory of prosecution that it wants to, and to the extent that it wants to include, whether it was intentional or unintentional in this case, which I'm assuming probably was unintentional as many of these were at the time, that if they want to go forward and submit to the jury that there's an instruction, or submit to the jury that the jury needs to find various alternative means, then they have to present sufficient evidence of each of those. And so in this particular context, I think that the only way that you could get an invited error rule, and I would still argue that you shouldn't because it's a sufficiency issue, but even if you were going to go that far, is if you affirmatively have some kind of request. Just failing to object to it, I mean, essentially puts defense counsel in this awkward position where you can't sort of just let the state go forward and then fail to prove what they've alleged here. And I think as defense counsel, you're allowed to do that. You're allowed to let the state go forward and then fail to prove their case and then make the argument that that was insufficient. And so I don't think that the defense counsel should be held to the standard of having to then affirmatively fix the state's problem under these sorts of circumstances. And again, I mean, we would still argue that because it's a sufficiency that we shouldn't even get to an invited error because the nature of it is such that they have to prove it. But certainly if you did go there, I would say that there still has to be some affirmative requesting to meet that level of invited error. Is that?
In other words, you're saying they don't have to lodge the state's objections.
Right. I think the state's perfectly capable of doing that themselves. So, so that, just to kind of clarify where we're at on that would be our position. With that, we'll submit the rest of our issues on the briefs and ask that this court vacate and reverse and remand for the same reasons that we asked for in our brief.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement